Right, good afternoon everyone. My name's Anthony, I'm not Tim, your regular lecturer. Tim is sick today, so Tim has asked me to come in and to conduct this lecture. So hopefully Tim will be better and be with you again next week. Tim wants me to make a few important announcements that he's already put up on Blackboard, but he wants me to go through them. Don't forget everyone, tutorials start next week. Remember that the tutorial questions have been posted on Blackboard under the Teaching Week 3 tutorial folder. And don't forget your preparation for this tutorial work is graded out of 2%. And please remember to have a photocopy of your written submission before you turn up to to give to your tutor at the beginning of the tutorial class. He's also asked me to remind you to remember to continue studying chapters 1 to 4 of the textbook because you need to prepare for a practice mid-semester exam which will actually be held in the first tutorial. That's teaching weeks 3 and 4, so it depends which weeks you've got your tutorials on, but I think the practice mid-semester exam is a very good idea because it actually trains you up for doing well in the actual mid-semester exam. So please make sure you prepare for that. And for any student who has their tutorial on the Exhibition Wednesday public holiday, so that's not next Wednesday, it's the Wednesday after, being Wednesday the 14th, you are allowed to attend any other tutorial during Teaching Week 3 and 4. So all you've got to do is go to any tutorial you like, tell the tutor you're from a Wednesday tutorial and you can't attend because of the exhibition holiday and they will let you in. Right, gang, en position. Let's begin with the first topic, sources of law. So, in this topic, we're going to go through statute law, common law, court structures, doctrine of precedent, statutory interpretation, and then I do have a third topic to teach you today, which is about the Australian Constitution. I'll give you a break after the first hour, just like Tim does, and let's get it done. Two main sources of law in the Australian common law system: statute law, that's law made by the parliaments, and common law, also known as case law. For an example of statute law, here's a typical example of state legislation. Acts Interpretation Act. So the way to tell a statute is they always have a title. There's the title there. The year means the year that the Parliament passed it, that it became law. And to work out which Parliament made it, because there's a few different parliaments, look at the abbreviation in brackets. So QLD, that's simply an abbreviation for Queensland. If it said NSW, that would be New South Wales, VIC, Victoria, etc., etc. Once you learn how to identify which parliament made the legislation, it's easy to tell Commonwealth legislation because you've got the same format of the title. You've got the title and the year that it was made. But Commonwealth, if it says CTH, that's easy. That's been made by the Commonwealth Parliament. Next slide. Now let's talk a little bit more about statute law. Here's another trick. Statute law actually has three names that mean the same thing. So if you hear the word statute, or if you hear the word legislation, or if you hear the word Acts of Parliament, it means the same thing, being law made by the Parliament. So don't think they're different things, it's just how it is. It's created by the parliaments. You've got the Commonwealth Parliament in Canberra, 6 in the states and 2 in the territories. Parliaments can also delegate their lawmaking powers to subordinate bodies. For example, Brisbane City Council is a government body that makes laws about the running of this city, Brisbane. But what would have happened is the Queensland Parliament would have passed an act of the Queensland Parliament giving power to the council to make laws for the governing of a city. Why? Because state parliaments need to focus on statewide issues. They haven't got the time to focus about the issues for smaller areas of power, such as cities or towns. So statute law not only includes laws made by parliaments, It also includes the laws made by these smaller bodies, and they're called delegated legislation. More about statute law. Now, they generally have a standard format. They're often given a number, a title, just like this one, Competition and Consumer Act. Date of assent is when it was passed. Enacting words, actually establishing that this statute is law. Commencement means, now this is a funny one, even though it's actually been passed, it doesn't actually mean that this is the day that the law applies. So you could have a law passed on the 1st of August, but it may not actually commence, actually become law until December. So if you see words like that, that's what the commencement date means. It could be when it's passed, or it could be a later time. And because if you ever look at a statute, there's so many words in it that if you print these things off, they could be roughly that thick on A4 paper. You need to order them in numerical sections. So the first section will be section 1, the second section will be section 2, etc. And then, under every section, you could have subsections. You could have section 1, subsection 1. Section 1, subsection 2. But again, it's following a numerical chronological order. And then you could have paragraphs. They're normally numbered in terms of little a, little b, little c, little d. So a typical one would read, section 1, subsection 1, subparagraph A, section 1, subparagraph 1, subsection B. So that's the standard way they set them out. It's to encourage regularity, so whenever you read a statute, people are used to this numerical chronological order. It can be divided into objects, parts, and divisions, and because they can be quite thick and confusing to understand, they often have their own definition section, which is a dictionary, an actual dictionary in the Act that translates words used in the legislation into words that people can understand, because they can get quite immense. A schedule is something at the back of the Act that simply lists certain things that the Act refers to. A common one is, I once read a piece of legislation that talked about offensive weapons. And actually at the back of the Act, it actually listed all the different types of offensive weapons that were banned in Queensland. So it listed nunchucks, flick knives, guns, etc. So that's a typical idea of a schedule. It's just listing out things that the Act is referring to. Next one. Let's get on to common law. So another trick, Australia has a common law system. That's the name of the system. Well, one of the sources is common law. Don't get them mixed up. The name of the system is the common law system, but common law is the body of laws created when judges report on cases that they hear and where they actually put into writing who will actually win the case and who will not. So there's a subtle difference. These are the decisions of judges of courts at the federal, state and territory levels, such as decisions made by the High Court of Australia, the state and territory Supreme Courts and the federal and family courts of Australia as well. And it's a funny word, common. Common comes from a bit of English history. William the Conqueror conquered England in 1066. Before he conquered England, England wasn't one country, it was a series of different Anglo-Saxon kingdoms. So you've got all these different kings, that means every kingdom has its own laws, which are different from the laws in the other kingdom. So when William the Conqueror conquers England, he thinks this is stupid, because he's now got one unified country. If you have different laws, people don't know which law to obey. So he got rid of all the Anglo-Saxon kingdom laws and instituted the same laws for everyone. And that's what common means. The shared laws that everyone must obey in a unified country. And it's also called common because the rules established by judges are consistent across all the jurisdictions. And where did we get the common law system from? From Britain. Basically everywhere the British Empire colonised, they left the common law system behind. Even America, who rebelled against the British Empire, kept the common law system from England. Next one. Now, follow me on this. So we've got the common law, But unfortunately, common law case law can be divided into two more categories. You've got common law, and then you've got the law of equity. And equity basically means fairness. So a bit more history. William the Conqueror establishes a common law throughout England, right? Then he sets up judges in courts to hear people's court cases. Now those judges are using the common law to decide who wins a case and who loses. But the funny thing is if you were in medieval England and you lost a case heard by a judge based on the common law, if you could convince the king that it was unfair, you could go to the king and you could convince the king to overturn, that means reverse, the decision of the judge in the common law court. And the king used to do it, and then he appointed a minister called the Lord Chancellor to take over because kings are busy and they need to do other things. And you had to prove your point that it was fair to redress. Redress means fix any deficiencies or problems with the common law. Now that's fair. If you lost and you got the judge's decision overturned, you'd then become the winner and you'd be pretty happy, but this led to a problem. If you won a court case before a judge on the common law, would you feel happy if the loser could then get it overturned by arguing that it wasn't fair? You would not be. So this led to a problem. Some people were thinking, why should I even go to court? Even if I win, if the other guy argues before the king or the Lord Chancellor it was unfair, I'll end up losing anyway. So over time, the courts thought, yeah, this is a bit ridiculous. It's making people lose their faith in the legal system. So eventually they merged both laws together. So these days when you go to court, you can have your argument based on common law rules and the rules of equity. So they didn't get rid of these rules that were developed over time, they've kept them. So they both operate within common law case law. Now this is funny, because when Tim really gets into teaching you like contract law and torts law and other issues, he'll teach you mainly common law rules, but every so often he'll teach you a law of equity, fairness. And when he teaches you a law of equity, when you read it, it could be completely opposite from the common law rules that he's just taught you. They do tend to say different things. So here's a problem. If you've got law of equity saying you can do this, but the common law saying you can't, which one do you follow? So here's a law to work out what happens if they ever conflict or go against each other, and here it is. If there's ever a conflict between a common law rule and a law of equity, equity will prevail. Prevail means be the dominant law and the common law rule will lose. So when he teaches it to you, he'll actually tell you this is a law of equity. As soon as you hear that, don't be confused that they seem opposite. They both exist in the system, but remember this rule. If they conflict, equity will win the argument, not common law anymore. Next one, gang. Now, Tim doesn't want you to actually read these things in detail. He wants you to prepare for your tutes next week and for that practice mid-semester exam, but it's a good idea just to see what these sources physically look like, just to get a sense of what they are. So have a look at this case law link in your own time this week, and he actually teaches you this case later this semester, Walton Stores. No need to read it, just scroll through it and get a sense of how big these reported case decisions can be. Like, there's a lot of words in these things. And if you want to see what statute law looks like, and that probably helps because if you scroll through the link to the legislation, you'll actually see this format. Title, date of assent, and you'll see the numerical section actually appear before you. No need to read it in detail, but again, get a sense of it, and again, there's a lot of words in statutes. Just to get a feeling, I think that helps. So talking about conflicts, not only can you have a conflict between common law and laws of equity, we've got two sources of law in the common law system. Common law case decisions from the decisions made by judges and courts, and statute law made in the parliamentary process. When you've got more than two sources, it is inevitable that you're going to have conflicts between these two laws. Sometimes students think the judges exactly know what laws the Parliament are making and the members of Parliament exactly know what decisions the judges are making, it's physically impossible for both parties to know what the other one is doing. They're too busy doing their own thing. So the problem is, and it's happened historically, you could get a statute that tells people you can do something, but you could get a reported decision of a judge, a common law case decision that says you cannot do it. Or you could get a common law case decision that says people can do this, and you'll get a statute saying you can't do it. What's the problem? People don't know which law to obey. So here's another conflict rule. If there's ever a conflict means they're not working harmoniously, but they contradict or go against each other. The rule is statute law will always overrule a common law case decision. You need to have that rule because if you don't, people will be confused and they don't know what to do. It depends on the wording of the statute. I remember as a lawyer, sometimes you'd read a statute saying this statute is meant to be read. Read means work in conjunction with the common law. That one's difficult. Most statutes actually have a section in the beginning that says in the event of a conflict between this statute and the common law, the statute will prevail. That's nice and clear for everyone. Now, the parliamentary process. And Tim does want me to emphasise the word usually. Usually each parliament in Australia is composed of 2 houses of parliament, and then there's a third step. So this is the case with the federal parliament in Canberra. This is the case with the parliaments in the other states, but not Queensland. So here's the process. You have the lower house. House of Representatives is what it's called at a federal level, and at the state and territory level it's got a different name, the Legislative Assembly. House of Reps is the one that you most likely see on television because that's where Scott Morrison and Anthony Albanese are. That's good media coverage, that's the one you most likely see. Then you've got the upper house, it's called the Senate at the federal parliament level, or at a state and territory level, the Legislative Council. Now the interesting thing is, the parliamentary process for actually passing legislation, it has to be done twice before you even get to the third step. For example, House of Representatives at the federal level, the way legislation is actually passed is some member of parliament has an idea for a new law. They've actually got to give a speech to parliament proposing to the entire parliament that this become law. Then there's a whole process because there's 2 major political parties in the House of Representatives. If one political party's member of parliament proposes a law, more likely than not, the opposing political party members will oppose the law, and then they enter this period called debate. So there's reading speeches, debate. If they need to send it to a committee of experts to get their opinion, they'll send it to a committee of experts to get their opinion. But at the end of the process, there's someone called the Speaker of the House. The Speaker of the House basically makes sure that the parliamentary procedure is followed, and the Speaker will say, we've had enough debates, we will now actually take a vote on whether or not this legislation will pass in this House of Parliament. And there's 2 ways to do it. They actually say, if you vote yes, put your hand up, and the Speaker will actually count how many people have put their hands up. And it's pretty simple. If the majority of members have voted yes, then it passes in that House of Parliament. But if the majority of members do not vote yes, that's the end of the legislation. It's gone. It'll never get passed, and you never hear about this in the media because people only report on the legislation that's passed. So be aware that not every piece passes. Sometimes they do and sometimes they don't. So now, you've got the upper house, and the way the system works is you need to do the exact same process again. The Senate has elected members just like the House of Rep, and when the legislation comes from the House of Representatives, they have to go through the same process again. And the Senate can pass its own legislation as well. So here's a question. Why are there 2 houses of parliament? So here's more history. There was once upon a time in England where the king had supreme legal power beyond the judges of the king's court. The king could make whatever laws he wanted, enforce them however he wanted, and if you objected to it, bad luck. He could interpret the way he wanted it, and generally he got what he wanted, not you. So if you owned a lot of land, he could simply pass a law taking your land, send his soldiers in to enforce it, and if you tried to complain before the judges of the king's court, he would tell the judges of the king's court to find the case against you. Bad luck. But by the 17th century, Englishmen started to get the notion of, yeah, we're subjects of a king, but we all are also citizens with rights. And there's certain rights that the king cannot infringe. And the king said, I can do whatever I want. Other Englishmen said, no, you can't. Parliament should be the supreme law-making power in the land, not you. And they had to have an English civil war to resolve the matter. And how did they resolve it? They cut the king's head off. England actually had a republic for 12 years after they did that. Now they haven't got a king. But you know what the Parliament is now worried about? Even though we've got rid of the king, we could end up being as bad a dictator or tyrant as the king was. Just because you get rid of someone doesn't mean you don't turn into them. So they came up with this idea that there's a risk, there's a danger if you just have one House of Parliament, that Parliament will end up doing what the king did and just making laws that hurt or injure its citizens. So how do we stop this? We have two Houses of Parliament. The idea of two houses is, oh mate, what are you doing to me? Hang on, this thing just shut itself off. Okay, thanks to you, Q. The idea of the second house is to stop the lower house passing laws that go against the rights or hurt its citizens. That's one of the Senate's roles. What does this mean in practice? Passing legislation, because it has to get a majority vote through two houses, is a long process, long. But there's a reason for it. To stop dictatorial laws being made by one House of Parliament. But even then, there's a third step. And this is a legacy of being part of the British Empire. The Queen or her representative, and the Queen doesn't live here, but she has a representative. At the Commonwealth level, the Governor-General; at the state level, governors, they have a role. And their role is they have to sign all pieces of legislation, whether made at the Commonwealth Parliament level or the state level, and they've got to give what's called the royal assent. Assent means the agreement of the British Crown to letting this legislation become law. And again, you don't read about it in the media, but every week in Canberra and in Brisbane, they print off all the laws made by the Commonwealth and Queensland Parliament, and some guy has to take it to the Governor or Governor-General's residence, and the Governor-General or the Governor literally sits there and signs. That's the royal assent. That signature is the agreement of the British Crown to this becoming law. Why is such a process still empowered? Because this was the agreement between the states and the federal government to form Australia, and I'll talk more about that when we talk about the Constitution. But the Governor-General and the Governor actually have a role. They have the power not to sign any piece of legislation if they think it's against the interests of the British Crown. They have that power. Now, I've never heard of a Governor-General or a Governor actually refusing to sign a piece of legislation. From what I've heard is they generally sign. But the fact that they have this power not to sign if they think it's against the interests of the British Crown is something that you've now learnt that most people out there do not know. They think the Parliament makes the law, but they don't know about the third step. And now we come to good old Queensland. Why is Queensland different? Because the thing is, we only have a legislative assembly. We've only got one House of Parliament, and it's the lower house. So here's more history. We once had two houses of parliament. We had the lower house and we had the upper house. We had the Legislative Assembly and the Legislative Council. But the thing about law made by parliaments is it's not just the process, there's politics involved. If you've ever suspected this, I'm telling you. So this is what happened. It was after the First World War, and there were two houses of parliament in Queensland. But because there's politics involved, sometimes you can get one party having the majority vote in one house, and you'll get the completely opposite political party having the majority vote in the other house. And political parties generally do not like each other. So what we had was this, and I don't remember the exact name of the parties. There was like a Labor Party in Queensland, and there was like a Conservative Party. It's not the same as the modern ones, but the ideas are the same. So what happened was this. The Labor Party had the majority vote in the lower house, which means if ever a Labor member proposes a law, you'll always get it passing in the lower house because most of the people who vote for the majority are from that political party. So they get what they want. But here's the problem. In the upper house, the majority of seats were held by the other Conservative Party. So guess what happens? Every time the lower house passes legislation, it passes in the lower house, but when it gets to the upper house, the majority, because they belong to a different political party, vote no. So what's the problem? States and countries need legislation to be passed to actually run the country. If no legislation is being passed, then the governance of the state actually grinds to a halt. So this is what the Labor Party does. They have a meeting and they say, we can't keep doing this because we want our laws passed. So this is what we're going to do. The next election, we're going to win the votes in the upper house. We're going to become the majority. They really campaigned hard and they won. So you'd think, okay, what's the problem now? Because if Labor passes it in the lower, Labor will pass it in the upper. The end. But Labor went a step further and they said, but here's the danger. We won this election, but at the next election, the Conservative Party might win the majority votes in the upper house again and we'll be back in the same problem. I know what to do. Upper houses can pass their own legislation. We will tell the majority members in the upper house who are faithful Labor Party members to pass a piece of legislation, and the legislation terminated the existence of the upper house. They actually passed a law that dissolved themselves, and it was gone. And that's it. And it's never changed. Now, back in just after the First World War, this was seen as a major political victory, but that's like over 100 years ago now. And what was the upper house originally created for? It's to stop dictatorial laws being passed by the lower house. So in this state, we only have one house passing it, the Legislative Assembly. How relevant is some political strategy from 100 years ago to our rights as citizens to have our rights protected now? Procedure in Queensland's different. You've only got one house, you get the majority vote, they print it off, take it straight to the Governor of Queensland, and if it's in the interest of the British Crown, they sign. That's the process that's different here. Next one. Let's move it up. So I sort of touched on this, but here's a nice diagram and some more detail on exactly how law is passed. Number one, someone's got to come up with an idea. That's what a proposal is for a new law. Now, it's common for political parties or members of parliaments to come up with their ideas for new legislation, but it's not limited to them. It can come from a range of sources, such as lobby groups. What's a lobby group? Sometimes you've heard this, and it's an association of business people who want a particular law passed, and odds on it's going to be a law that helps them in their business. But lobby groups can be any group of concerned citizens who, if they get organised enough and feel strongly about something, can actually petition. Petition means try to persuade members of Parliament that what they're concerned about should be made as past legislation. In other words, don't think that when you see laws being made on TV that this is what they do. If you feel concerned enough about something and you think there should be a law that supports it, you can form a lobby group, and if you eventually persuade members of Parliament to propose this before the Parliament, then there's a possibility that this could become law. You have that ability. Comes from other places as well, media. Sometimes there's media lobby groups. They get the laws they want through, as well as government departments. Now, every parliament has someone called a draftsperson. Drafting means to write, and this person's sole job is to write up the proposed draft legislation, and before it's passed, it's got a funny word, it's called a bill. Bill means not the actual passed legislation, but the proposed legislation. They might also prepare an explanatory memorandum, which is a plain English explanation that most people can understand, trying to explain what the law is trying to achieve, summarising it and explaining the effect of each section or provision. The bill is initiated in the Parliament, so they'll get one member of Parliament to stand up and say, I wish to propose the following bill. That's called the first reading. Then it goes through a second reading. Now, committee means the members of Parliament can decide whether or not to do this, but the thing is, just because you're a member of Parliament doesn't mean you're an expert in the area of law that the law is about. For example, if they wanted to pass a new law regulating the engineering industry, I guarantee you most members of Parliament are not engineers. That's okay. You get a committee of independent engineers and you get their expert opinion on whether or not they think the law is a good idea and what the law should say. And that's a really valuable part of the process. Members of Parliament generally concentrate on getting elected, so at least you're getting these other opinions of people who actually work in the field, and they're taken into consideration as well. And then the third reading. After the third reading, it's vote time. Majority votes, it passes that House. Majority doesn't vote, that's the end of it. And then you've got to do it again, as I said before, in the upper house. There's the royal assent of the Crown. Nothing happens unless that signature from the GG or the Governor is applied to that document. Next one, gang. So now we're going to look at the hierarchy of Australian courts. Hierarchy basically means an ascending order of importance from the bottom to the top. And this is how the court system works in this country. They play a fundamental role in our legal system. They're vital to the operation of law. They allow for a system of appeals, different forms of hearing according to the seriousness or gravity of the matter, and something I'll teach you called the doctrine of precedent. So there it is down the bottom. It's the ranking from lowest importance to higher importance to higher importance from the bottom up. And we've got a federal hierarchy of courts, and we've got a hierarchy in every state as well. And here's a diagram that Tim's done for you to give you a very basic understanding of how this works. Down the bottom, lower courts. Why? Of lesser importance that hear different matters. Then in the middle, intermediate courts, then supreme courts, then the highest court in the land, the High Court of Australia. That's on the state side. Commonwealth's a little different, but the idea is the same. Federal Magistrates Court is the lowest ranking court in the federal hierarchy. Then you've got the middle rankers, the intermediate courts, Federal and Family Court. Then their highest court in their hierarchy is the High Court of Australia. So what does it mean if I go back for appeals? A basic definition of appeal is if you lost your case the first time you went to court, you've got the right to appeal, to have a second chance to fight your case again. But where you appeal is, not in the court where you lost, you've got to move up the hierarchy, and that's where you try and appeal your decision where you lost the first time. And this is another legacy of the English Civil War. There was a time in England where if you lost before the courts and you could not convince the king it was unfair, bad luck. You had to live with being the losing party. But then, over time, people thought, this is not fair because judges are human. They don't always make the correct decision according to common law and the rules of equity. People should have the right to appeal if they feel strongly enough about it. So if we go back to this diagram, if you were down here in the Queensland court system and you lost your case in the magistrates court, you have the right of appeal to the next court up, which is the district or intermediate court. If you lost there, you can keep moving and moving to the highest court in the land. The High Court of Australia is the final court of appeal in this country for both the state and territory court system and the Commonwealth court system. That's the ultimate endpoint. A couple of practical points of appealing. You have the right, but you need things. Number one, if you lost in a court, you can appeal up, but you cannot use the same legal argument where you lost. You've got to come up with a new legal argument. So maybe you can, or maybe you cannot. It depends what you can do there. Second thing is, when you lose a court case, your lawyers don't go, there, I won't charge you. Your lawyers say, there, where's our money? So you need the funding to keep moving up the appeal process. A lot of people don't have that. So even though the right's there, there's some practical considerations to whether or not this happens. Let's have a look more at the federal court hierarchy in detail. So way down the bottom, we've got the federal court, circuit court. Then it's funny, at the middle level, the court splits into two ways. The whole idea of the federal courts is it hears matters concerning disputes about the legislation made by the Commonwealth Parliament. That's its main reason for its existence. It will hear arguments about common law, but that's primarily what it does. So on the left-hand side, Federal Court of Australia, if you go there the first time, that's what original jurisdiction means. If you lose in the Federal Circuit Court, or the first time you went to the Federal Court, you have a right of appeal to the full court of the Federal Court of Australia. That's what appellate jurisdiction means. You lose there, you can go straight to the appellate jurisdiction of the High Court of Australia. Then on the other side, you do have a separate court system for hearing family law. Family law is a Commonwealth piece of legislation, and because it's so complex and fraught with emotion, they've set up separate courts to deal with family law matters. Tim doesn't teach you family law, just be aware of its existence. Again, the appeal process is evident in the diagram. They all end with the final appeal to the High Court of Australia. Established in 1903, as I've said, highest court in the land. And here's the trick, it's not just for the federal system, it's for all state and territory structures as well. High Court does three main things. They hear appeals from the federal courts and the state court systems. They hear disputes between the states and disputes between the states and the Commonwealth. Not reported much in the media, but every month the states and the Commonwealth are fighting about who has the legal power to make laws about certain areas. So they don't go through the state court system one by one and keep appealing. They go straight to the High Court of Australia original jurisdiction. You can't waste the states and Commonwealth time by making them go through the lower courts. They've got the right to go straight to the High Court. And the High Court has the judicial power to interpret the Australian Constitution. That's why it was established. Now be warned, sometimes in your textbook you might see a case decided by an English Court of Appeal called the House of Lords. So even though this court was set up in 1903, for a good number of years after, if you lost your appeal in the High Court, if you had the money and the guts to do it, you could go to London and try and appeal before this English court called the House of Lords. But that's no longer the case. So if you see that, don't get confused. Those cases decided by the House of Lords are still case decisions, but this doesn't happen anymore. It's the High Court of Australia that is the final court of appeal. More about the High Court. If you go there the first time, such as you're a state having a dispute with another state or with the Commonwealth. You could go before a single judge to hear disputes about the federal law, or 5 to 7 judges if you're fighting over the Constitution. And they hear matters, as I said, where the Commonwealth is a party or disputes between the states. But if you go there to have your final appeal, so you've come up through the federal or the state court system, you might be before 3 or 5 or 7 judges, because they hear appeals from the state, territory, Supreme Courts, the federal court hierarchy, the family court, or from any high court judge where someone had their matter heard the first time under original jurisdiction. And as I've said, it is the final court of appeal from the decision of any state or territory court. It's a part of each system. Remember, it's a part of each system. Sometimes students think, oh, the High Court is only federal. It is the father of all court systems, whether a state or territory or federal. And you don't just go to get an appeal simply because you've appealed up through your state or federal system. You've got to go through something called special leave. So it's not the actual trial. You've got to convince the judges that they need to give you the time to have a proper trial, because what you're arguing at this level is something that where the law needs to be changed or the law needs to be reformed, or not just you need it, but everyone in the country needs it. And who's a great example of that? Eddie Mabo. Know him? He's the guy who got the Commonwealth Parliament to institute native title legislation. But he didn't lobby Parliament. He actually took the matter to one of the Queensland courts to say, I have title as a Torres Strait Islander to my land. At the time, people thought, nah, if you don't have title to land under the Western property system, you don't own it. And he said, bugger this. He lost the first time. You know what he did? He appealed. Lost the second time. Know what he did? He appealed. And that's what I need to tell you. That's what it takes to actually get all the way to what you want. And when he went to the High Court of Australia, he said, I'm not just arguing on behalf of myself, I'm arguing on behalf of all Indigenous people in this country. We need native title recognised. He convinces the judges to give him the time to hear the matter in the court, and guess what? They said native title exists. And then there was this whole media outcry. People were saying yes, other people were saying no, but eventually the Commonwealth Parliament passed legislation called the Native Title Act that backed it up. But that takes courage, but it can be done. Next one. So here's a quick question. And Tim's instructed me to give you a bit of time to think about it. Put your hands up when you think you've got the answer. Which of the following describes a power or function of the High Court of Australia? A, the High Court has original jurisdiction. B, the High Court is the highest court in the state, territory and federal judicial structures. C, the High Court hears appeals from both the federal and state court systems. D, the High Court has the judicial power to interpret the Constitution. E, all of the above. And why does Tim give you this stuff? Because he's training you to become accustomed to the questions that you'll get in the mid-semester exam. So 10 seconds, turn to someone next to you and ask them, what do you think the answer is? Start talking, gang, and then we'll put our hands up. 10 seconds. 10. 9. 4, 3, 2, 1. Who says the answer is A? You sure? Because I'm telling you, A is sort of correct. Have faith. Who says the answer is B? It's not bad. Who says the answer is C? Who says the answer is D? That means you've been listening. Who says the answer is E? Correct. Good. Know your content, and I'll warn you, watch out for options like E, all of the above. You need to be absolutely sure that all of the above are correct, because I've seen all of the above questions where 4 of them could be correct, but 1 is wrong. Let's watch it. Next one, go. Let's have a quick look at the state, territory and court hierarchy. And again, it's ascending importance from bottom to top. Magistrates' court is interesting. The most popular court in the court system because it only hears certain ranges for compensation, and most people's claims against each other for contract law breaches are really low amounts. Busy court, but effective. There's a trick there. It only has original jurisdiction. It does not have an appellate jurisdiction. So if you went to the magistrate's court and lost your case, you don't hear an appeal in the magistrate's court. You move up to the appellate jurisdiction in the district court. Watch that. Now, district court also has original jurisdiction. Your matter might not fall within the parameters of a magistrate's court, so you can go straight to a district court the first time. And if you lose in the district court, it's okay. You stay in the same court, but under its appellate jurisdiction. Then, if you lose in the district court appellate jurisdiction, you go to the Supreme Court. But what's the trick? You don't go to original jurisdiction, because original means where you go the first time. If you're appealing up, you don't go to original, you go to the next court's appellate jurisdiction. That also means there are certain situations where you can go to the Supreme Court the first time. You can skip magistrates and district, depending on the matter and depending on how much money you're claiming from the other party. But where does it all end? The High Court of Australia appellate jurisdiction. If I were you, I'd study this diagram and be very familiar about how exactly you can move up on appeal and how exactly you can go somewhere the first time. Next one. What time does Tim give you a break on the hour? Oh, the voice of the people. I'll keep going. So let's have a look at state or territory Supreme Courts. So now we're in our own state, Queensland. Let's start from the top and work our way down. As you know from the diagrams, that's the highest court at a state level just within Queensland, but the ultimate higher court is the High Court of Australia. Supreme Court, the first time you go there, original jurisdiction, you could go before a single judge. They have an optional jury of 6 in civil matters. Most of what Tim teaches you is civil matters. But you'll have a jury of 12 when they hear those criminal matters. When you see on TV that someone's been found guilty of murder, that trial would have been held in the Supreme Court original jurisdiction in most cases. Unlimited civil and criminal jurisdiction within the state or territory, but it also has its appeal jurisdiction, either as a full court or a court of appeal with 3 judges. Here's appeals from other state and territory courts lower in the court hierarchy. Moving down, the intermediate is the Queensland District Court. Now here's something interesting. A good way to work out where you go the first time for original jurisdiction is how much money you're trying to claim from the party you're fighting with. This is called the damages range. To go to the original jurisdiction of the district court the first time, you've got to have a civil matter that's less than or equal to $750,000 at the top of the range, but more than $150,000 at the bottom of the range. District still hears criminal matters, but the serious crimes, such as the one you see on TV, murder, go straight to the Supreme Court. District also has appellate jurisdiction, because they're hearing appeals from the court below it, which is the Magistrates' Court, but sometimes you can go directly from MAGs, that's magistrates, to the Queensland Supreme Court as well. Depends on the matter. Then heading down to the most popular one, it's the Magistrates' Court. They hear civil matters from $0, I don't know why you'd go to court for $0, but apparently you can, up to $150,000, and it's the most common everyday criminal matters, like shoplifting and speeding and traffic offences. Now, sometimes on TV, you'll hear a story about the Magistrates' Court and they're talking about someone murdering someone. So sometimes students think, oh, the Magistrates' Court hears serious criminal matters. That's not what's happening. A committal proceeding is the magistrate trying to work out if there's enough evidence to actually take up the time because time for judges is very limited. The time of the judges in the Supreme Court to actually devote to a full-blown, long-lasting criminal trial. So what the magistrate is trying to work out is not if the guy accused of committing the crime is guilty, but if there's enough evidence to actually justify using the court's time at the Supreme Court level. So that's what a committal proceeding is as well. Now, here's the trick. To work out in a civil matter where you go the first time, and first time is original jurisdiction, know your damage ranges. So let's have a pretend question. Let's say you're in a contract and this person promised to pay you money and they didn't. Which court would you go to the first time if you were suing this person for $50,000? The first time. It's got to be magistrate's original because 50 falls within 0 and 150. So here's a good one. How much money would you need to go to the district court the first time? How much would you need to claim? And here's the trick. The damage range for one court begins where the other one exactly finishes. You're going to laugh. Hey? And 1 cent. No kidding. Because magistrate ends exactly at 150, so they can hear it for 150. So what do you need for the district court? Anything over 150? 150 and 1 cent. Now, Tim hasn't done it, but I told you the damage range for a court begins where the other one ends. So how much money would you need to go if you were suing someone in a civil action to go to the Supreme Court under original jurisdiction the first time? How much would you need to claim? I'll go back to this one. Where's district finish? $750,000 exact. So how much would you need to go to the Supreme Court under original jurisdiction? $750 and 1 cent. How much can you claim in the Supreme Court? There's no limit. So that's another one you see in the media. That's where the big boys make big claims. 10 million, 20 million, 2 billion, there is no limit. That's where the big companies fight their battles. Let's keep going. I'll give you a break at 5. You're doing very well to stay alert. So this thing is not a court. Tribunals are not a court, they're something else, but they're designed for a different purpose. They still hear matters about the law. A judicial body means a court. These are quasi. Quasi means semi-judicial bodies. They're not part of the court hierarchy because, strictly speaking, they're not courts. They're not bound by the rules of evidence. You know, Tim doesn't teach you this, but there's a whole law about what evidence is valid before a court case and what is not. That's why law students hate learning it, because it's so intricate and complex. But you don't need the laws of evidence in a tribunal, which is good, because here's the killer point. When you go to court, you can represent yourself, but judges and magistrates hate it. And the reason they hate it is people can argue their own cases before the magistrates, district and supreme, but because they don't know anything about the rules of evidence, they're constantly getting their evidence wrong, and it makes judges wild with anger. They hate it. And there's also rules of court procedure. Lawyers know these rules of evidence and court procedure, but people who represent themselves, they're making mistakes here, they're making mistakes there, and judges hate it. So you've got the right, but you just end up in a loop for the next 10 years, because every time a judge sees you on the court list, they say, not this guy again, put him back to December. You need lawyers to be effective in the court system, and the problem with lawyers is they will demand their payment. So here's the big difference with the tribunal. You do not need a lawyer to represent you. This is not a court where judges want you to have a lawyer. It's actually been designed for ordinary people like you and me to represent ourselves, and we don't need a lawyer, which means we don't have to pay for a lawyer. It's actually designed for ordinary people to state their case You don't need the laws of evidence. You don't need the laws of court procedure. All you do is dress well, rehearse, have your evidence in writing, and present to the tribunal member. What's the trick? The primary tribunal in this state, in fact the only tribunal, is QCAT, the Queensland Civil and Administrative Tribunal, and it hears matters, not all matters on all laws, but certain matters, but the damage range is 0 to 25. So don't get confused, because sometimes students go, hang on man, you've got this one from 0 to 25 and you've got magistrates from 0 to 150, they're conflicting. They're not actually conflicting. You can have a lawyer in the Mags Court for 0 to 150, or you can represent yourself from 0 to 25 grand. One particular one of interest to students is, given most of you rent, if you ever had a dispute with your landlord, you could pay a lawyer $300 an hour in the Mags Court, or you could represent yourself if your claim is under 25 grand in the QCAT tribunal. So it's actually designed to make justice more accessible for people who cannot afford a lawyer. Know the limits and know its parameters. I'll do a question and then I'll give you a break. Warnie is a tenant of a rental property in Brisbane. He has a dispute with his landlord because Warnes mistakenly overpaid the landlord the sum of $150. I think Warnie must have had a direct deposit thing set up in his account, but he let it get away, so he's overpaid this guy $1.50. But of course, the landlord denies receiving it. Which one of the following is the best venue for Warnie to bring his action, given he cannot afford a solicitor to represent him? A, the Queensland Magistrates Court. B, the Queensland Tenancy Court. C, the Queensland Civil and Administrative Tribunal. D, the Queensland Coroner's Tribunal. I know what a coroner's court is. That's when a coroner tries to work out how someone who's died. Or E, the Queensland District Court. 5 seconds. Turn to someone next to you and see what they think. 5. All right. Who says A? Who says A is wrong? It is wrong. Why? You can represent yourself in court, but you'll have a bad time if you can't afford a lawyer. Who says B? Who says B is wrong? Correct. There's no such thing as a Queensland Tenancy Court. It's a made-up answer. Know your content. C. Correct. Why would you go to the Coroner's Tribunal? A, it doesn't exist. D, the coroner asks how someone died. It's got nothing to do with this. Why is E the wrong answer? 1, you need a lawyer. 2, how much is he claiming? 1,005. 1,005 falls neatly within the 0 to 25 grand damage range of the tribunal. There's actually 2 things going on here. The damage range makes C the right answer, and the fact he can't afford a lawyer makes C the right answer. How long a break does Tim give you? 10 minutes? Oh man, I don't know if I can get through the rest if I give you 10 minutes. How about 5? All right, here's a compromise. 7. 458 plus 7 equals what? See, this is why I did law. I'm not very good at maths. Huh? Make it 506, since you negotiate so well. Come back at 506, have a break, stretch, eat something, get on the WeChat. 506. Am I going to get through this? Yeah, I'm going to have to run that. Okay. Okay, we'll start in about 1 more minute, as soon as it hits 5:06. Okay. Okay, let's restart. So the next thing you need to learn about is this concept called alternative dispute resolution. This is a way of resolving disputes without wasting the time of the court and the judges, and without it costing people the cost that it takes to hear a full-blown trial of a matter before the court and judges. Occurs before the proceeding commences. There's 3 main types: arbitration, mediation, conciliation. Why are they a good idea? It's generally cheaper, faster, more private and less stressful to have your fight resolved through these processes than going to court. It's less destructive to ongoing business relationships. No kidding, when 2 businesses have done business for a long time and they tend to have one dispute about one contract, they'd rather get this resolved through these processes because they're probably more likely to keep doing business with each other in the future. It is possible to fight with someone, but to keep doing deals with them. But when you go to court, I can tell you now, it's so costly and stressful, you'll never do business with each other again. You end up hating each other forever. And even though I've shown you a lot of courts in those diagrams, you might think there's a lot of judges with a lot of time to hear matters. There's more people who want to fight before courts than there's time for judges to give every matter its full due. They simply do not have the time. It's one thing to go to court, but you've actually got to get in a queue. Once you file your action, you could be waiting 1 year to 2 years before you get your time in court. Why go through the stress when you can solve it in these ways? Now, they seem the same, but there's subtle differences. Arbitration. You're not heard by a judge, you're heard by someone called an arbitrator. You present your arguments to the arbitrator, both of you, and your evidence. And after hearing both sides of the argument, the arbitrator makes a decision, a determination as to who will win the dispute and who will not. But the subtle difference on arbitration is, bound means must follow. So if you agree to go to arbitration, you must follow the decision of the arbitrator, which means if you win, you'll be happy. But if you lose, you'll be pretty angry because you'll always be thinking, maybe I could have got a different result if I went to court. So you need to know what you're walking into when you choose to do arbitration. Mediation seems the same, but there's a big difference. You don't present your arguments to the mediator. The mediator is there to try and bring you and the person you're fighting against together to get you to resolve your disputes. So they're not actually making a decision, they're getting you to work it out. But no advisory role, because when you go before an arbitrator will actually say, I think this guy's argument is better than yours, that's why I'm going to give it to him. A mediator can't say that. They can't give an opinion on who's got the strongest argument, and they cannot determine it. That means they can't make a binding decision. So if you two can't work it out yourselves, your only option is to go to court. So sometimes people are upset with mediators. They think, why didn't that guy tell me who wins? They don't do that. That's not their job. And conciliation is a little bit different. They're called a conciliator, but they again help the parties, and they are actually advising as to who's got the strongest argument, but they still don't make a determination like an arbitrator. So don't get confused. There's subtle differences that can mean a lot if you're someone before them. Benefits of a hierarchical model. Most cases, civil and criminal, dealt with by the lower courts. The magistrates' court is a lower court that really hears cases quickly. They just burst through matter after matter after matter every day. That means there's a benefit because the workload between all these courts is shared, and as I've taught you, you have the appeal system. You need a certain practical approach to it, but the right is there. Now, here's something interesting. If you watch shows on TV about lawyers or going to court or cop shows, sometimes students think judges make the laws. This is not true. If a judge walked in that door and if you asked him or her, do you make the law? They said, I don't make the law. I interpret the law as to how it applies to the case in front of me. And how do they do it? There's two ways. The doctrine of precedent and this really tricky one, statutory interpretation. And these are two fundamental areas when judges make case decisions. So what's precedent mean? In making a conclusion as to who wins and who doesn't in a case, they go through a big process of legal reasoning and thinking. And number one, precedent means judges must look at previous cases decided by judges in courts in the past. And again, Tim doesn't want you to read that case, Waltons versus Mayer. But when you look at it and scroll through it, you'll see there's a lot of words in a typical case decision made by a judge. Most of those words will be something called, and it's a funny term, ratio decidendi. That's Latin because a lot of English law came from Roman law. Ratio decidendi means the judge's reasoning for who won the case and who did not based on the law. The judge's legal principle reasoning based as to who had the strongest legal argument. It's those reasons, the ratio decidendi, that then form the precedent of past cases that judges in the present might have to follow when they make decisions on similar areas of law. And the thing about ratio decidendi is binding. Binding means if a judge, subject to other laws, must follow the decisions from the past, that means they have no choice. They are bound to follow it. But here's the trick. Ratio decidendi is binding, but this other thing called obiter dicta is not binding on future judges. So just trust me on this. Most of the words you see in a case decision will be ratio decidendi, right? That's the judge's role. He or she has to hear the legal arguments from the plaintiff and the defendant. They've got to go away and think about it, and then they've got to give this big judgment based on the law as to why someone wins and someone loses, and most of it is ratio. But then you get these things at the end called sayings, by the way, are just comments. If they've got nothing to do with the judge's legal reasoning as to who had the strongest legal argument, that type of stuff is not binding on future judges. Not binding. That's the first rule of the doctrine of precedent. Next one. Let's get more into more rules about this, and I'll ask you a question. Here's the rule. A judge who has to decide a question of law that's been considered by an earlier court may, so may could go either two ways, have to decide the question in the same way as were done previously. Why? The law system needs a lot of things to actually operate. It needs courts, it needs judges, it needs police. But one thing it needs is, it needs people to believe in the law. And this doctrine, its real purpose is to make sure that when a judge makes a decision now, that they're consistent with what has happened in the past. And that's necessary for people to have faith in the law. Because there's countries where judges can make whatever decision they want depending on how they feel that day. So if the judge is in a bad mood, you'll go to prison for 10 years. But the next day, if the judge is feeling happy and someone else breaks the same law, they'll let them go free. But if you had those types of decisions, why would people obey the law anymore? What's the point in going to court if it's going to be a gamble as to what the outcome is? So by following the doctrine of precedent, it gives people faith that something that has happened in the past in terms of a judge's decision will be likely to happen now. That consistency is important. And so precedent means what has happened before, falls two ways. Binding precedent means the judge must follow a decision of the past, but here's the two rules to make binding. It's got to be a decision of a judge in the past, of a court higher in the court system than where the current judge is. And it's got to be within the same hierarchy of courts. If those two rules are satisfied, then the judge must follow it, it's binding. But judges can choose to follow precedent decisions from other hierarchies, but that's the judge's choice. It's up to the judge whether they do this or not. And that's what persuasive precedent is. Decisions made by courts outside of the hierarchy are not binding, but may be persuasive, but that's the judge's choice. The judge can choose to follow it or not. So, for example, if I go all the way back to this diagram, see this pyramid from the lowest to the top? That could be the Queensland hierarchy, in fact it is, but you'll have a similar one in the other states, New South Wales, Victoria. So if you were a judge in the middle of the district court, and 2 years ago in the Queensland Supreme Court, there was a decision on the same area of law that you're hearing a fight about right now, you would be bound to follow it. Why? Because it satisfies the two rules. One, the Supreme Court is higher than you. Would you be bound to follow a decision made by a judge 2 years ago in the Queensland Magistrates Court? The answer is no. Why? Because it's lower than you. Higher than you, you have to follow it, and it's in the same hierarchy, which is Queensland. But if you've got this hierarchy in New South Wales and you're still a Queensland District Court judge, and 2 years ago there was a really great decision in the New South Wales Supreme Court, which is a different court hierarchy, are you bound to follow it, or do you have a choice whether or not to follow it? It might be higher, but you're only bound when it's in the same hierarchy. If it's a different hierarchy, you do not have to follow it, but you can choose to follow it or not. Know your rules of binding and persuasive. Next one. We'll get there, I hope. This is what I said before. It gives people certainty that what has happened before will happen again. It gives you predictability. Like when you go to a lawyer, you want an opinion on whether you're going to win or lose. They'll look at what's happened in the past to give you that prediction. If you win, great. If you lose, it's better you know you're going to lose now and go to alternate dispute resolution than to waste money and actually trying to fight it in court. And uniformity. Uniformity means people get this sense that it doesn't matter who you are, where you're from, what your blood is, how rich or poor you are, you will get the same decision as has been made in the past. And it's not subject to the judge's personality. Now, even though I've just taught you all that, you're going to love this. You can go against the rules I've just taught you. So there's some flexibility here as well. It takes a brave judge to do this, but judges can also do the following. Distinguishing means making a difference from. So if a judge feels that the case they're hearing now is so different on the facts and the circumstances from what's happened in the past, the judge can say, even though I'm bound to follow the past, I can distinguish this case now because it's so different from what's happened in the past. And a judge can also say, even though I'm bound to follow the past, those judges in the past made the wrong decision at law. So it is possible, and look, the law needs this because people's attitudes and technology changes. Like we are now entering a world where you can get contracts made online and an artificial program will actually design the contract for you. This is different from the time when people would actually negotiate it face to face. So this is necessary for the law to keep up with the times. But it takes a brave judge to do it. Why? Because if a judge said, I'm not following the past precedents, you know the loser of the case? Guess what they're going to do? They're going to appeal. And what's the law argument for their appeal? This judge failed to follow the rules of a binding decision. So it can be done, but you need to be forthright in your reasoning. Next one. You think that's difficult? This is difficult. It's the world of statutory interpretation. So as I've said before, judges don't make the law, they interpret the law, and they interpret common law and statute law. And here's the problem. Sometimes when you read a statute, easy to understand, but sometimes it's hard to understand, complex, confusing. And here's the problem. I taught you that there's draftspersons. They draft the bill, and then when it's passed, they draft the final version. It's their job to draft the legislation. But the problem with legislation is it falls into two categories. Legislation either says you can do something, or it says you cannot do something. Whatever it says, it's actually got a list in writing, all the ways you can do something and all the ways you cannot. But here's the problem. Those draftspeople probably have to write 10 different pieces of legislation on 10 different areas of law at the same time, and one's due on Monday, the other one's due on Wednesday, the other one's due on Friday. It's a hard job. And the thing about humans is, we're very good at reading something that tells us we cannot do something, but if it doesn't list something they haven't thought of, we are very good at getting around that problem by doing what the law did not list. It's physically impossible to list in a statute all the ways people can do something or cannot. And if you told a draftsperson to sit there and draft it until they did, it would take them 10 years to do it, and then someone would read it and still find a way of getting around it because it cannot cover every possibility. So the problem is solved by judges actually interpreting whether or not statute applies to a particular case. Now, it's such a complex area that there's actually statutes for the interpretation of statutes. I'm sorry, but this is what it is. They've got them at a state level, like the Queensland Act Interpretation Act, and they've got it at the Commonwealth level for interpreting Commonwealth legislation. So let's focus on this approach called the purposive approach, which is common to a lot of state acts, and it's in the Commonwealth Act as well. So when a judge has a dispute about what a statute means and whether or not it applies to the facts of two parties fighting before the judge, here's how a judge needs to interpret the statute. The way the judge has to interpret it is in a way that best achieves the purpose or object of the act. Another word for that is, what's the reason for the legislation? And that's how you interpret the legislation to best achieve the reason for the legislation even existing in the first place. So if you were asked this by Tim, the first thing you need to work out is, what's the purpose, what's the object, what's the reason? Now, here's another problem. Sometimes when you read a statute, way at the beginning there'll be a section called the purpose section. And that's good, because it'll actually say, in English, the purpose of the act is, and then it'll spell it out for you clearly. Like if you get that, that's easy to work out. But sometimes it's hard to work out. You know, those draftspeople have to draft statute about really complex areas, and even when you read the purpose section, it still doesn't make sense. Or maybe there's even no purpose section. So in those situations, it's possible for a judge to look at things that are extrinsic to the legislation. Now, extrinsic in English means something outside of something else. So what it's actually saying is, if a judge reads the statute and can't see the purpose of the statute within the four corners of the legislation, the judge can look at other documents that might actually tell him or her what the purpose of the legislation is. And this is where judges can actually look at this material. You can look at it as a judge if you need assistance working out what an ordinary person would think the words of the Act means. That's what the ordinary meaning conveyed by the text of the provision means, number one. Number two, you can look at extrinsic material if any of the words in the legislation is ambiguous. What's ambiguous mean? Capable of more than one interpretation. And that's a problem with the English language. Some languages only have one word that only ever means one thing. But in English, one word could mean two things or three things or five things depending on the context. That's ambiguity. Or obscure. What's obscure mean? Not clear, hard to understand, confusing. So that's when a judge can also look at extrinsic materials. Well, here's a good one. If you read the ordinary words, but it leads to a result that is manifestly means to a high degree, absurd or unreasonable. Absurd, ridiculous or silly. Unreasonable, no reasonable person would think that reading the ordinary words would lead to a result that is good for society. Complex, but I'll give you some case examples soon. As to what extrinsic material actually is, 15AB lists the different types, so here are just some examples. If a draftsperson drafts an explanatory memorandum that has the nice, clear English translation of what the legislation's about, you will find the purpose of the legislation in that memo. When Parliament sends draft bills off to committees or royal commissions, I guarantee you somewhere in the report of those committees, they'll talk about what the purpose of the legislation is. When that Member of Parliament introduces a bill, they just can't say, I want this legislation because I feel like it. They've got to actually say in their speech what the reason or the purpose for the legislation is. And if for some bizarre reason you can't find it there, you'll find it in the debates when they're actually debating it between the political parties. So there's all these different sources. But to demonstrate what this is about, let's look at two cases. Fisher versus Bell. So there's a guy who owns a shop called Mr. Bell. His shop has a front window displaying the goods he wants to sell. And in that window is a flick knife. You can flick knife? You know what a knife is? Here's a knife, right? Watch me. Blade, handle. What's a flick knife? It's mainly handle. The way it's designed is the blade hides inside the handle, so it either shoots back or flicks in. Why? It's designed for sneak attacks. Because if someone has a flick knife, they'll approach you like that. Because if they had a knife, you'd see the blade and back off. But because their hand's like that, you've got no idea what they're going to do. They click the button and then they put it into your rib cage and kill you. This is not a good thing for people to have. Not. So there's an act called the Restriction of Offensive Weapons Act, and here are the literal words of the act. Here's the ordinary meaning of the act. Any person who sells, lends or gives an offensive weapon, and in the schedule, remember I told you schedules list things, it listed all the weapons that were prohibited. Guns, nunchuckers, flick knives. If anyone sells, lends or gives an offensive weapon, they commit an offence, which means they breach the legislation. And this guy, Mr. Bell, had in his shop window flick knives for sale. You could see the knife like this and there was a sign, flick knife, $10. And this policeman walks past, sees it, goes straight in the shop and says, I'm charging you with a breach of the Offensive Weapons Act. This is your time in court. And Mr. Bell goes to court and he is found not to have breached the legislation. Why? And this is the problem with the ordinary meaning of the words. How do you break the legislation? You sell, lend, or give an offensive weapon to someone. But when the policeman arrested Mr. Bell, did Mr. Bell sell the knife to the policeman? No. Did he lend the knife to the policeman? You know, lending. Here, have a knife, but I want it back next week. Nope. Did he give the knife to the policeman? Nope. You know what that means? On the words, he hasn't breached the legislation. Now, if you were Mr. Bell, you'd be pretty happy because you're not guilty. But I'll ask you a question. What's the result of such a thing? Because what's going to happen to that knife? Is it going to sit there forever? It's going to be sold to someone. What are they going to use it for? Cooking? Killing? So whilst this is good for Mr. Bell, do you think you would think this is a good result for society? Or is this a little bit absurd, a little bit silly, or a little bit ridiculous when they discovered that the purpose of the legislation was to stop people getting access to offensive weapons? So this is a demonstration of statutory interpretation. The draftsperson didn't have enough time to think of all the other ways that weapons could go from one person to another, and that included displaying weapons for sale. But when you read it, it doesn't say anything about displaying weapons for sale. You either sell it, lend it, or give it, but you can display it and not breach the act. This is a stupid result because people are going to use these things and they're going to use these things. Second case. Smith versus Hughes. The Street Offences Act said prostitutes cannot solicit, that means get clients, in the street. And this is what I mean. People will read statutes, and if something's telling you not to do something, but it doesn't say another way you cannot do something, people will say, oh, it's silent, and they'll get around the legislation. So the smart prostitutes said, you know what we're going to do? We won't try and get clients in the street. We'll go into a house, go up to the second story and get on the balcony and we'll tell clients to come into the house. So we're not standing in the street when we do it, which means we're not breaking the legislation. Now, if you're in the business, you think you're pretty clever, but if you're a family person walking down the street with your children, I mean, you can see and hear what's going on. Do you think that's a good result for society? Do you think that's a good result when they looked at the extrinsic materials, the purpose of the legislation was not technically to cover actions in the street, it was to stop prostitutes soliciting customers in public. And what happens in public? Other people see things, other people hear things. People with their families are seeing this occurring before them and trying to explain to their children what's going on. This is an absurd result. This is something unreasonable that no reasonable person would think is reasonable. So even though it doesn't say in houses and on balconies the way the judge interpreted it was, it's still a breach of the act. Lucky last question, and then we'll do const. I hope. Which of the following is an example of extrinsic materials under 15AB of the Commonwealth Acts Interpretation Act? A report of the committee submitted before Parliament passes legislation. B, the written submissions of lobby groups to a Member of Parliament asking for a new law to be passed. C, the first reading speech on a draft bill by a Member of Parliament. Now watch it. D, both A and C are examples of extrinsic material. E, now watch it, all of the above. 5 seconds. All right, I'm not going to go through them. What do you think the answer is? Say it. And maybe I'm going to have to call the vote in. Who says A? A is a little bit right, but is it completely correct? Nope. Who says B? If you think B is wrong, good, because it's not listed in the examples of extrinsic materials under section 15AB. Who says C? C's a little bit right. Who says D? D is the most correct answer. So watch it. Tim's trying to train you on another multiple choice thing. You've got to watch all of the above, and you've got to watch answers where they combine two answers together. Sometimes it's that, and sometimes it's not. But it's not E. Why? Because B is wrong. So watch all of the above. Sometimes it's the right answer, sometimes it's not. You're doing very well to stay awake. It's a lot to take in, and to be honest, I'm doing well to stay awake too. So let's get through the Constitution. We're going to look at federation, the Constitution itself, the division of powers, which is the most interesting bit, inconsistencies between the Commonwealth and state laws, and how you get it changed. So, to recap from last week, Tim taught you this. Australia's under a federal parliamentary system of government. It's not just a political union, but an economic union of the states in the Commonwealth, created by an act of British Parliament. A lot of Aussies out there think the Australian Parliament passed the Constitution. We were still under the governance of the British Empire. And it's the blueprint for the concept of the Commonwealth, how the new federation would be established, and the guidelines Australians would shape their nation. And we became a federation on 1st of January 1901. So it might seem boring, but this is the ultimate law-making power document in the country. It's the Australian Constitution. So, it established the federation of the colonies, which became states, the sets of rules that govern the country, and the legal framework for actually getting the country operational. Now, I'll blast through these chapters because we need to get to the good bit. Chapter 1 was all about establishing the parliament known as the federal government, which consists of the Queen. Now, kings and queens come and go, but what it really means is the British Crown, represented by the Governor-General, House of Representatives and the Senate. Another name for it is the Parliament of the Commonwealth. And as I just taught you before, two houses, gang. House of Reps is the lower house. You've got equal representation. The number of the members chosen in the states shall be in proportion to the representative numbers of their people. You get electorates, divided approximately the same number of voters. You get about 150 electorates in the country. As near as practicable, has twice the number of senators, etc., etc. Election every 3 years. Then we've got the upper house, which sometimes you see on TV as well, not as much as the House of Reps, known as the Senate, also the upper house, or a funny common term, the States House. And apart from stopping dictatorial laws made by the lower house, another reason for its existence under the Constitution is to represent the interests of the states. Because when federation occurred, not everyone in the British Crown colonies of Queensland, New South Wales and Victoria actually wanted to be part of a unified country called Australia. So this is a concession to preserving their fears about a central government having too much power. It's meant to preserve the laws of the states and the rights against a central government that has too much power. More populous states, however, can potentially be overbearing. New South Wales and Victoria generally have more power than the others. Each state currently has 12 members, 2 per territory, and the election is every 6 years. But when you voted last time, you probably saw elections for both houses, so they do tend to correspond mathematically. More. Oh, here we go. Which of the following is the correct title of the current upper house in the Queensland Parliament? Ah, Tim. A, the Queensland Senate. B, the Legislative Assembly. C, the upper house. D, the Legislative Council. E, oh my God, none of the above. 5 seconds. 5, 4, 3, 2.5, 2, 1, 0. Who says A? Who says B? Who says C? Who says D? Who says E? E is the right answer. It used to be another answer, but they got rid of the upper house. It's a trick question. How many houses does Queensland have? 1. Let's keep going. Now, 2 houses doesn't mean they necessarily always agree. Section 57 talks about a disagreement between the House of Reps and the Senate, and this once happened. It's a bit like the Queensland story. You get legislation passed in the House of Reps, they always vote for it, but if the Senate doesn't, what's the problem? No legislation gets passed, the country cannot be governed. And this is another aspect of the power of the British Crown. If this keeps happening, the Governor-General has the choice to dissolve. Dissolve means everyone is kicked out of the houses and they have to run elections again. Have a look at the process in your own time, know the steps. It's called double dissolution. And will this ever happen? Yeah, because it once happened in 1975. Whitlam Labor government dominated the lower house, but Malcolm Fraser's Liberal National Alliance dominated the Senate. They're different political parties, they're not friends. So every time Labor passes majority in the lower, Senate says no. What's the problem? No law being made, the country grinds to a halt because one of the laws you've got to make every year is a law as to what the federal budget will be. You know what the budget is? The money to operate the country. You don't pass the law, no money gets distributed, everything shuts down. And so the Governor-General said, I haven't got a choice. I'm going to dissolve both houses and both of you can run for election again. They had the election and Labor lost. Liberal Nationals for the next 10 or 12 years. The British Crown. Next one. Chapter 2 talks about the executive government that consists of the Queen, GG and Executive Council. What's executive power? It's the power to actually run the functions of government to make sure that people obey the law on a daily basis. It's vested in the Queen, exercisable by the GG as the representative. You've got a federal executive council who advise the GG and chosen by the GG. And they can appoint ministers of state, which are elected members of the winning majority government, to become the heads of Commonwealth government departments. You either got to be a member of the House of Rep or a senator in the Senate. Chapter 3 sets up the judiciary, outlines the judicial power of the Commonwealth, creates the federal court system and the high courts. You know about appellate and original and appellate jurisdiction. Here's an interesting one. It says if you are a judge in the federal courts and you hit the age of 70, you have to retire. The image of judges is often old people who are out of touch. There is a limit on it. Next one. Financial and trade powers under Chapter 4. Oh, remember the money? This is the money. It's the Consolidated Revenue Fund. This sets up where our taxes go. Because when we pay taxes, it hits the Central Consolidated Revenue Fund in Canberra, and then the Commonwealth decides how this money is distributed back to the states and the country. Highly important. 5 and 6 regulates the relationship between the states and territories with the federal government. Every state still has a state constitution. You never hear about it because no one cares anymore. But that's a relic of the British Crown colonies being paranoid they'd lose their constitution, so it still preserves them. But of course, the states have their parliaments and their laws. States definitely want parliaments and laws. And Section 109 I'll talk about soon. Chapter 7 established the capital because there was a big fight between Sydney and Melbourne. So they said, you boys can't play together nicely, we'll make it an independent place, and it's Canberra, the cow paddock, and the powers of the Governor-General are set out there. And Chapter 8 talks about how you can alter, change or amend the Constitution, which I'll get to in the end. So here's the interesting bit. This is what the Constitution really does. It divides lawmaking power between the federal government and the states. Because sometimes students think the federal government can tell the states what to do. That's not a federal system. The idea of it under the Constitution is the state is not subordinate to the federal government. It shares lawmaking powers between themselves. It's meant to be a partnership. And this is a result of the years of negotiation it took to get people to eventually vote yes to a federal system. So the federal government would get certain powers, the federal government would share powers with the states, and then the states would retain other powers. So it falls three ways. You've got exclusive powers, Section 52. Exclusive means only the Commonwealth can make certain laws about certain areas. Only the federal parliament can make these laws, not the states. Then you've got concurrent. That means at the same time in English. And these powers are shared, exercisable by both the federal and state parliaments. And residual means in English everything left over. It's basically powers the Commonwealth didn't want to exercise. So these powers are not expressly identified as exclusive or concurrent, but because the Commonwealth doesn't want to do them, guess who exercises them? The state parliaments. And this diagram is a good way of explaining this concept. On that side, good examples of exclusive powers. Exclusive means only the federal parliament can make laws about these issues. Customs, defence, currency and territories. And when you think about it, they're really about issues that need a national approach to them. Residual, way at the other end, it sort of fell into the lap of state parliaments because the Commonwealth didn't want to make laws about them. But this generally means only the state parliaments can make laws about these areas, such as education, property, crime and health. Now the one in the middle is the most interesting. This is the legacy of people in the Crown colonies fearing the federal government having too much power. They said, look, we'll agree to a federal government, but we'll share these powers because we don't want to give you too much. So this led to the creation of concurrent powers, where both federal and state parliaments can make laws about the same areas, such as taxation, marriage, banking and external affairs. So here's the problem, and it's a bit like common law and statute law. You've got two sources making laws. They could work together, but they could come into conflict on a regular basis because they're not exactly watching what the other one's doing, and it's not their job. So thank God for Section 109, because the writers of the Constitution could see this problem coming, and they put in a mechanism to solve the problem. And this is what it says. When a law of a state is inconsistent means contradicts, conflicts or fights against a law of the Commonwealth, the latter in English means the last law that we spoke about, shall prevail, shall be the dominant law, and the former, that means the first law we spoke about, to the extent of the inconsistency will be invalid. So what does that mean? Tim's got a question on it. Let's see if you can do it. For example, there was gay marriage legislation before the Commonwealth passed the National Act just in the ACT. You know what happened with this legislation? When the state passed it, the federal parliament freaked out because they were like, wow, we've got laws that sort of prohibit this at a national level, but now you've got a state law saying you can do this. So this is a typical example of the conflict that can happen. What subsequently happened? Thank God for politics, because there was such an outpour that this should be a national law that eventually the Commonwealth government at that time, who was the majority party, woke up to what people wanted and actually did the referendum and then passed the legislation. Quick questions. What's the venue for resolution of disputes when there's ever a conflict between federal and state powers? Easy. What's the highest court in the land? High Court of Australia. 2. What's the venue for resolution of disputes regarding any interpretation of the Constitution? Here's a clue. It was set up for this purpose. Guess which court it is? High Court of Australia. Can the Constitution be changed? So I've only got 2 minutes left, so I'll bust through this. Section 128 says you can, but I want you to read it in your own time and think about how easy or hard this process is. So it's a bit like appeals. The possibility exists, but the process is quite long and laborious. Study it in your own time. Know it. Because even though it can be changed, there's been 44 attempts since 1901, 36 have failed. Why do you think that could be? I haven't had time to run through the process, but if you look at all those steps, is that an easy process or a long, hard process? And other things play a role here, such as people's attitudes at the time and such as people's politics at the time. So quickly running through these. 1951, the government of the day wanted to amend the Constitution to ban the Communist Party. They did not get that amendment through. Why? Because even though people were freaking out about the Cold War, most people thought, well, if you start banning one party, then you can start banning more parties and more parties and more parties till there's only one party left. And that's not a democracy. 1967, Indigenous Australians to be counted in the populace. It went through the amendment, so it was recognised in the Constitution. Why? Because by 67, people had changed their attitudes from the 19th century about how this country should treat Indigenous people. I'll keep going through them all, but the one you should really focus on is the Republic. That's the last one Tim's got. 1999, not carried. And that issue has disappeared from the media and from politics. It comes back every so often. But at that time, they went through the full process and people said, no, we still want our ties to the English monarchy. So it's not just the process, because if you don't get any of these stages in the process, going back here, like if it stops at stage 1, that's the end. If it stops at stage 2, even though you got stage 2, that's the end, etc., etc. But you've got to think about what people are feeling and what they actually care about at that point in time. Oh, mate, it looks like you didn't have a question on section 109, so I'll give one for you off the top of my head. I know you want to go, you're doing very well, but here we go, and then you can bugger off. Let's pretend there's a state law that allows you to do something. It says you can do something, but there's a Commonwealth law that says you cannot do it. And they're both validly made laws under the concurrent powers. Well, you've got one law saying you can do something and the Commonwealth law says you cannot. How do you work out which law the people must follow? What is the answer under section 109? Which one will be the dominant law? Commonwealth over state or state over Commonwealth? One more time. When a law of a state is inconsistent with a law of the Commonwealth, latter means the Commonwealth law shall prevail, be the dominant law, over the former. Who's the former? The state, to the extent of the inconsistency. Know your section 109. All right, you've done well to maintain your focus. Have a good evening. Good luck. See ya. See you, gang. Have a good week. See you, mate. Oh, man. See you, mate. Oh, question?
Yeah.
What is it, mate?
The question was in terms of the binding precedent and the persuasive precedent.
Yeah, go on.